Hello and welcome to a Faxosaurus Explainer. Today, we'll be diving into the HIPAA privacy rule and when medical information belonging to you, a patient, can be shared with other entities. When you have first contact with any medical practice, from independent specialist to your primary care physician to the emergency room, you're handed a big stack of paperwork to sign. Included in this paperwork is the practice's health information disclosure, which aligns with the HIPAA privacy rule and details how your medical records can be shared and with whom. Let's take a look at a generic health information disclosure form. It's divided into sections, and we'll go over each one. The for treatment section. That's pretty obvious. You're at a hospital, so they need to know what's in your medical records to treat you. For payment, they need ways to track you down if you have an outstanding bill caused by copays or insurance not covering things. For healthcare operations, they need your medical information to compile into quality of care statistics, which includes a wide range of things, like making sure people are being cured, appointments are happening on time, checking to ensure you're receiving the recommended care for your condition, and risky procedures aren't being performed unnecessarily. Your medical record, along with everyone else's in the facility, is used to generate these statistics. Facility directory. This is so when someone calls in and wants to see if you're there and can identify you by name, the staff will be able to disclose your location and general condition. Clergy can also ask for this information, and you can explicitly opt out of it being disclosed if you want to. For others involved in your care. So this one is for folks like your family members, friends, partners, and things like that, so they can call in and actually get more detailed information with what's going on with your care. Fundraising. Sometimes there's a fundraising clause, and often it says your information won't be shared for fundraising purposes, which is good. Required by law. There's laws that require mandatory reporting of things like gunshot wounds, knife wounds, suspected abuse or neglect, or other such injuries. Public health. Healthcare providers are required to disclose certain communicable diseases like a measles diagnosis to public health authorities such as the State Health Department or CDC. In case of a disease outbreak like E. coli, that information will be disclosed to the public health authorities as well. Law enforcement purposes. If law enforcement is looking for a fugitive or missing person who matches your description, or if you're a material witness to a crime, the healthcare provider can share limited information about you with law enforcement. Judicial and administrative proceedings. Your medical records can be subpoenaed in a lawsuit or criminal trial. A judge has to sign off on this first, of course. Health oversight activities. Information can be shared in the course of oversight monitoring, such as checking for Medicaid fraud or an FDA investigation into the safety of a medical device or insurance compliance audits. Descendants. If you die, your information will be disclosed to medical examiners, coroners, and/or funeral directors. But at this point, I don't think you'll be too concerned. Organ tissue donation. Also, if you die and you're an organ donor, the hospital can let people waiting for transplants know what good parts are left. Research. Your medical records can be used to identify you as a possible candidate for a clinical trial or research, and if you authorize it, your health information can be disclosed as part of a clinical trial. Health and safety. This is a duty to warn type of thing. If you tell a healthcare provider you're planning on harming a specific person, your medical records may be disclosed once that provider contacts law enforcement. Obviously, don't do this. Government functions. If you're in the armed services and upon medical examination, it's revealed that there's a condition that might affect your fitness for duty, that information might be disclosed to your commanding officer. Workers' compensation. This one is for your workers' comp claim. If you are injured into the job and come into the hospital and making a workers' comp claim, your medical records can be disclosed to the relevant workers' compensation insurance carrier. Business associates. This means all kinds of the supporting IT programs, electronic medical records providers, and other associated services and tools that need access to your healthcare information. A really wide range of entities fall under business associates, but luckily, all of those business associates have to safeguard and not share your health information as well. Other uses and disclosures. Because the rules around healthcare information sharing are so strict, this is kind of a cover clause to allow a provider to leave messages reminding you of upcoming appointments or bills, which are also protected healthcare information. So that was a little deep dive explainer on the HIPAA privacy rule disclosures, which is just one part of all those forms you have to sign when you visit the ER or start up with a new doctor. Hope you enjoyed this and learned something new. Thanks for watching.